And now we want to get back to the bench. What a surprise out of the A.J. Armstrong trial. We were expecting opening statements this morning.
But things came to a screeching halt when the judge announced she is postponing this third trial for another week. She said the issue was, quote, something that was outside the court's control.
And the stop-and-go nature of this trial has been very difficult for everyone involved, dating back to 2016 when Don and Antonio Sr. were murdered inside of their Southwest Houston home.
We have a lot to talk about with our criminal experts coming up in just a few minutes. For now, we want you to meet the team.
All right, let's do this very special evening edition of The Bench. We've been at this all day, by the way. The players, real quickly, this is Brian, attorney, Joel, reporter, Letitia, attorney, Rilwan, reporter. That's our panel of experts, and we're going to get right to it because today was not what we expected. What happened in there?
Well, we thought it would be opening statements, not at all. As they mentioned earlier, there was an courtroom issue that happened, but we believe it has to do with the motion that was filed last week from prosecutors trying to bring in an expert witness that was once a lay witness, I believe you would say, Letitia.
What does that even mean? It's the classification of who this person is?
That's exactly what it is. A lay person is just a fact witness, someone who's going to come and give the facts about what they saw or what they know, as opposed to an expert who will more than likely give an opinion as to the evidence.
Does that make a difference, by the way, to a jury of what you call someone? Yeah.
Of course it does. An expert witness has the background. You know, there is a rule that we call 702 where someone has to be qualified to be an expert witness. That means there's going to be greater weight added onto their testimony because of their background knowledge and their expertise.
So they're delaying everything now at this point until Monday. That's when we expect to hear opening statements. What is happening in between now and then? Are there still operations going on and motions going on in this case?
I don't think that there will be anything going on within the courtroom because you remember before Judge Johnson dismissed everyone this morning, she asked both sides, is there anything else anyone else needs to take up? Both sides said no. So I think what both sides will do is go back to the bench and start focusing on, okay, what could I have tightened up on? What witness could I have been tightening up on? And of course, both sides will be getting ready for this new expert.
Do we have an understanding of who this expert is, what their role is? Who is this?
So this is the VP at alarm.com. Prosecutors want to use them to kind of talk a little bit about what happened at the home system the night of the murder here. And defense have really been poking holes into the prosecutor's argument that the alarm system was not perfect. There's a way it could be triggered, and that's what they're alleging or claiming at this point. And prosecutors are bringing this person to kind of talk about the material itself. The issue and why we believe it's being delayed till next week is the prosecutors apparently didn't give them enough time, defense team. And Brian, correct me if I'm wrong, you mentioned that 20 days, but that's not law or anything. That seems like something Judge Johnson has kind of set forth.
Exactly. There is no rule, regulation, case, or statute that says you've got 20 days. The 20 days that we've all spoken of is in the judge's standing discovery order. And again, as everybody who's binge watched Law & Order recognizes, that's a critical part of the process. It's all about notice and fairness. And I think Letitia makes a great point. 702 says when an expert walks into court, they are cloaked in this notion of being Batman. Now, on the other hand, noted legal sage Mark Twain once said that an expert's, just some guy from out of town.
Right.
But in the real world, experts do matter. And what I really think the defense is going to be doing in the next 6 to 7 days is not only seeing if they can find any more dirt on the state's expert, but more importantly, getting an expert of their own. Because you can't bring a pop gun to a gunfight. If you don't have your own expert who walks the walk and talks the talk and can call this guy out like a punk, then you are in deep, deep trouble, everybody.
All right, let's talk about real quickly the importance of the burglar alarm, because that is really the linchpin of this case for the prosecution, right?
Absolutely.
Their contention is what? That nobody came or left. It was just those core 4 that were in the house.
That's it. That's the whole argument, that the alarm system worked just as it needed to, that it would have meant that someone inside the home committed the crime. They said in their opening statement in 2022 that the alarm wasn't set off until officers came in, and then AJ turned off the alarms, claiming that the alarm was set, so no one broke in. It had to have been someone inside the home at the time.
The big thing to keep in mind this whole time is this is the 3rd trial, 2 hung juries prior, and this is how at least one juror interpreted the alarm evidence in the last trial. Can we give a listen to that?
I don't see them going to sleep not knowing that their home is secure. So to me, the house is secure, so I don't see, there's no physical damage,
You're good.
of intruders, or it just, I mean, the murder is still in the house. It was pretty obvious to me. And then I feel like the note was just a distraction to make you think it was from someone else.
Was there one piece of evidence that they were really hung up on, or was it just kind of a collection of different things?
Yes, they just kept going back to the alarm system and how there was a testimony on how it may have not been fully functioning. So that was their main focus on, like, how can we really rely on the alarm records if there was a testify that it wasn't really functioning fully. So that was their main focus.
All right, so that was one juror's take. I think she was on the opposite end of what what everybody else went up with, though. Everybody else seemed to, no, she would be on the same side because she didn't believe she didn't believe the defense. Am I the confused one? Yeah. She doesn't believe the defense is what I'm hearing out of that bite.
Congratulations.
But that's not the way it went.
Congratulations.
That's not the way it went. That's all I'm saying.
Yeah.
All right, we got to keep moving, and I'm slowing us down. So the next thing we want to talk about here is the courtroom. It was packed today, and both of you were inside of it.
We were.
Who's in there with you?
All of A.J. Armstrong's parents, family members, it feels like at this point, so many family members. We have the sketch artists, and cameras weren't allowed in the room.
We paid
money for a sketch artist. That's Armstrong with his wife, Kate. They stayed together for most of the time until Armstrong had to leave the court for whatever reason, and then he came back. Along with him sitting next to them, to Kate's rights, I believe, was one of her friends. Kate's mom was there. Grandparents were there. They sat in the back. They were watching through the whole thing. So it was very packed. The first 2 rows there were all family members. Family members really jam-packed there. We saved you a seat because we were like, it is filling up really quickly here.
That's right. Yeah, luckily you guys did save me a seat. Otherwise, I wouldn't have had one. But it was packed with family members, and that's important. As I stated before, you always want the jurors to know that your defendant is someone who truly is cared about. You want the jury to understand that he's just not some lone ranger out here by himself, and that when people take the time off work, take the time of whatever they have going on in their lives to sit in court for 8 hours a day, that says a lot about what they think of that human being. And as I stated earlier, it sends a subliminal message to the jury. This person comes with a little bit of credibility. Let's pay attention to what's going on, because all of these people are not here supporting someone who's a jerk or who's a monster, right? And you would have to be a monster to kill both of your parents.
As far as I know, every member of his family is in AJ's corner on this.
Every last one of them, every grandparent, family members, aunts, uncles, and we're talking about the mother, father, sister, and brothers of the deceased.
Okay, they're telling me, they're giving me signs that I have to show them. We've paid such good money for this, so we have to now generate. This isn't going to work well.
Don't rip it, Joel. We paid for that.
This is worth hundreds of dollars.
Right there.
Okay. That's a nice one too. That's his sort of. Is this an actual perspective? I'm just curious.
No, yes. So where the sketch artist was sitting right at this point, I believe was in front of you to the corner right. Yes. So this is accurate to where this whole court setting was. This is Armstrong right there, and that's Judge Kelly Johnson. This is moments before where we were all told opening statements would not happen today. Brian, I'm curious with you, your thoughts on how would prosecutors kind of combat what we just heard there? There is a lot of family members. Family members will likely be here through the whole thing. Well, is that a problem that they will have to attack in any way?
Absolutely, because I think that with the family there, this makes this defendant an outlier. I think if you stuck your head into any courtroom in the Criminal Justice Center, I'll take the under on the number of defendants that have the kind of family support that this young man has. But I really think that the prosecutors, Ryan Trask and John Jordan, a couple of heavy hitters, are going to come up with a narrative, and I don't really think that this is a spoiler alert, that merely because this young man has family support doesn't mean that he didn't pull the trigger on his parents. And that while he may look like a kid, that at the end of the day, the evil that we ought to fear the most is the evil that we don't see coming. Ladies and gentlemen, that's your defendant.
Okay. We are going to, right now, bring you back to the rest of the news in the studio. So we're going to check in with Keith and Daniela on this camera right here. And on KPRC 2 Plus, we're going to continue this conversation. And we have barely gotten through this rundown. So we hope a few of you managed to work us in as well. That's on KPRC 2 Plus. Let's send it back to you guys.
All right, some very fascinating stuff there, Joel. Thank you, sir.
Thank you, Joel.
All right, Frank, in the Storm Tracker Weather Center.
Always watching, always tracking. His next update in just a few minutes.
And the FBI is investigating the sexual assault of a child on a flight from Houston to Sacramento.
New tonight and only on 2, you're going to hear from the girl's mother. That is next at 6 o'clock. We'll be back.
I thought this was kind of interesting. Was this a result of one of the motions is that Rick DeToto, lead defense attorney, can no longer what? He can't thank? Or what's going on with that? He can't thank the family members?
This is what we call a motion in limine. And folks, it's not inside baseball. It really matters. True or false? It's important, because it's basically designed to keep either side, usually the defense, from blurting out something really bad that's going to taint the jury, that won't be subject to the jury being told, forget what that guy just said, it's all BS. And in this situation, the motion in limine, your typical motion in limine is 3 things. Don't mention the right of appeal. Don't talk about punishment. If punishment's not an issue, and make sure you watch the bench on Channel 2. Those are usually the 3 things I see. But this was personal. This isn't business. This is Rick DeToto shouldn't move around the courtroom. Rick DeToto cannot turn to the audience as he's done before in opening statements and thank the family for their trust, because that's really not proper argument. So this is something where Ryan Trask and John Jordan have fired a shot across the bow at the defense and said, don't do it.
Is it not proper argument because you're not addressing the court and you're addressing the gallery?
Because it's not what the evidence is going to show. I'm confident that I read on the internet what the purpose of an opening statement is, which is it's what the evidence is going to show. The evidence is not going to show that these people trust you. It's what you intend to show, and that's why we saw that motion in limine that says, folks, this is personal, it's not business.
And that was to everyone. No one will be allowed to speak with the gallery at all, prosecutors or defense. But prosecutors did call out DeToto saying, please do not thank grandparents for being in the audience there.
Did he have a beef with that, or is it just like, okay, I won't do that?
No, there wasn't any back and forth. The only thing that DeToto did push back on a little bit was about walking around. He said he has some issues with his back, and then every now and then he would need to stand and walk a little bit. And I think the judge, I don't think she agreed with it. She just made a motion. She was like, no, you can't do that either. So
that's that. Okay, we had in here, but we were thinking we were still going to be on TV at this point. But we were going to talk about what's next from here. Mm-hmm. We'll kind of circle back. We're all over the place a little bit. But what is next from here? So you guys told me at the beginning of this thing that not a lot is going to happen between today until Monday morning?
Nothing literally in court. I think it's all pretty much pre-gaming. I think it's going back to your office. I think it's taking another look at your PowerPoint, because when I started in the Ice Age, nobody knew what PowerPoint was. You got it if you read from a legal pad. Everybody uses PowerPoint now in your openings.
That is correct.
And I think that it's part of putting on a show. It's a narrative. And I have a little thing on my computer printer that says, if you don't tell your story, somebody's going to tell it for you. Ain't that right?
That is correct. You definitely want to tell a story. I don't know about the show, but I definitely want to tell the story. And I want to tell my client's story. And that's very important. And you can count on Rick DeToto to do just that. The fact that the prosecutors were saying, don't thank the family, shows you exactly how powerful it is, the fact that they're in there. They know that that's evidence that is quiet. Rick may not be putting on that evidence, but the fact that that entire family is there, trust me, is evidence that the jurors are going to consider.
Has the judge put a time limit on how long the opening statements can be?
45 minutes max.
How does that sort out for a common, is that short, long? Where are we at?
I think for for a case like this is rather short, in my opinion. I would think that she would give them an hour, hour and a half. As I've stated before, I've given a 2-hour opening before, but of course that was in a big chemical plant case. But in fact, normally on a case such as this, we're talking about 2 homicides. We're talking about capital murder. 45 minutes is not a lot of time.
But I think in your typical case, in your no test Friday night DWI, in your stop and rob, the guy's caught with 6 nuns and 2 rabbis as witnesses, a lot of lawyers may not even make opening statements. And I think that's a mistake, because Robert Hirschhorn, who I know Letitia's worked with, who's the guru of jury consultants, says most jurors make up their minds after opening statement. You never, ever want to give up that opportunity to speak and let these folks know what your narrative is going to be, guys.
I'll tell you, in the second trial, 2022, the prosecutors took about 22 minutes. Defense took about under 30 minutes, about 29 minutes. So that's something else I'll be clocking for. I'll have a little timer right there, just trying to see how long it takes.
And that's not a bad deal either, right? Because the human's attention span is not very long. So if you can summarize your story within 30 minutes, that's even better. But you want to make sure that you hit all the points. You want to make sure that you lay a roadmap for the jurors to follow. And you better make sure that you follow through with what you promise them they will see.
Talking about that roadmap, we want to give a listen real quick. This is throwing us way back to 2022 in the second trial. This is the opening statement, I think, from the prosecution, correct? Ryan Trask delivered that. I don't know if he's delivering it in 2023. But here's what he had to say, or a portion of what he had to say back in 2022.
In the months leading up to the parents' murder, the parents were constantly getting on this defendant. You're going to see text messages. And what those text messages will show you is that they were constantly accusing him of lying. He had failed out of school, and they were constantly getting on him about tutors, about spending too much time with his girlfriend, about many issues that I anticipate that you're going to hear about. And quite frankly, at the end of spring of 2016 and into the summer, his parents were at wit's end with him, especially the mother, Donna Armstrong.
There's essentially, I picked those bites out, guys. I was doing some work today. So what I wanted to show is sort of the different ways that both the prosecution and the defense are positioning what the family dynamic was, or at least the dynamic between mom, dad, and son. And you're going to hear it. It's on 2 opposite sides of the spectrum. But is that important, is my question, as we heard that, to lay out, to mitigate what the relationship was? I mean, is that important to establish off the top?
You absolutely have to. Because at the end of the day, this jury, to convict, has to believe beyond a reasonable doubt that this young man executed his mom and dad as they were in bed. And for your typical Harris County juror, that's something that's going to be a heavy lift. And to do that, you've got to provide context, and that's exactly what we heard.
I agree. However, they're going to need more than that, because those of us who are parents and who are raising teenagers in this day and time, if we're worried about them executing us because we're getting into it, then we're all going to be dead, right? So, and people who are parents know that. I certainly had my issues, with my younger daughter, and I would hope that some of the issues and the text messages that she and I had would not lead to murder. So in my opinion, they're going to need more than that, but they certainly have to lay that groundwork.
Right. It's not all that uncommon for teenagers to be disrespectful to their parents, not listen to the rules. That's not so outside. If we can we listen to this is now how the defense, and I think this is Rick DeToto, positioned that dynamic.
Now look, he's 16 years old at the time of the incident. And everything that they say about AJ, you have to filter through a 16-year-old mind. You have to think about it. What is his maturity? What is his intelligence? Did AJ have problems with his parents? Ladies and gentlemen, how many 16-year-olds don't have problems with their parents? Stand up if you know anyone.
Essentially, Rick DeToto saying what we just said, isn't it? He's essentially saying, look, this dynamic exists, or kids and parents don't always get along. It doesn't mean you're murdering your parents. Is that the linchpin to get people there? Do you have to get just one juror to think that way?
That's all you need.
That's all you
I
need.
have hung a jury before with one juror. With one juror. And the second trial, because they retried my client as well, they stopped the trial in the middle of the trial and dismissed the murder case. So imagine if that one juror had not hung in there and wasn't strong enough. That man would be convicted today. It was 11-1 to not guilty. So all you need is one.
Well, and that's a great point, because if our viewers ever have some time, the next time 12 Angry Men comes on, Turner Classic Movies, you need to watch it, because it talks about Henry Fonda being in the position of Letitia's juror in a murder case where it looked like the evidence was obvious from here to there. I've been on a jury. I've never been that holdout, but I can't imagine what that would have been like to have been the juror in your case, let alone Henry Fonda and 12 Angry Men. It takes real courage to be able to stand your ground in that jury room, guys.
And that's what they were trying to find, those people in the voir dire process. They were asking each individual person, if someone said X, Y, and Z, how firm would you stand in your belief? And a lot of them said squarely.
Well, but then again, prosecutors have a way of kind of getting around that during final argument, where they're saying essentially, the defense wants you to get a divorce on your honeymoon, folks. Just go back there and give it a little time before you decide you want to hang this jury.
Yeah, really. Yeah, they kind of press the jury into not being hung, right?
One of the things that I always say to empower a juror is this. I ask them to take a look at their new best friend, you know, when they're in the panel. Take a look to your left and take a look to your right. Is there anything about your new best friend that you just met that will allow you to make the most important decisions in your life or your children's life? And no one ever raises their hand and says, sure, my new best friend can make those decisions for me. And then I tell them, well, don't let them make new decisions for you, my client. The same way that
Did you come up with that tack? Is that patented?
Thought of it all by myself.
That's pretty good.
It's like Otter on Animal House. It's got to work better than the truth.
I like that.
Absolutely, absolutely. It works, and it empowers them.
That's interesting.
We got two good attorneys here. Okay, so they're also, during all of this, continuing with everyday court business, right? So, like, before any of this got started, or I guess didn't get started this morning, there were a bunch of things on the docket, weren't there?
I'd say Judge Kelly Johnson saw maybe 7 cases this morning before we got to Armstrong's. And then even after I stayed for a little bit, she was going through so much more. There's the backlog in Harris County Criminal Courts. This is known widely that there's this backlog. And just because she's doing this trial, as you mentioned earlier, at 8 a.m., that it doesn't mean that everything stops in this courtroom.
No, we can't afford for it to stop. It stopped for Harvey, and it stopped for the pandemic. We can't allow any more cases to be backlogged any more than it already is. And so because of that, she has to continue to run the business of the courtroom. As you can see, she got rid of 7 cases off the docket today, all while this case was set to start at 10:30 a.m.
And this is common practice, even if you've got a big old trial going?
It's common practice. It has to go on.
Do you always knock out that business first in the morning?
You try to knock out as much of the business as you can. The judges are always going to tell the jurors to come back at a certain time. And at the time that those jurors get back, that is what is going to trigger the judge to start the trial, because judges are very, very sympathetic to a jury's time. And so when those jurors get back there and they're ready to go, the judge is going to be ready to start the trial.
And Judge Johnson explained that to the jurors. She said, while you're at lunch, we'll be in here doing business. Just don't believe if I send you back to the jurors' room that we're not handling business, because the court remains open.
You know, there's a reason why we rise when the jury enters the courtroom as we do when the judge comes in. They're the most important pieces in this chess game. And for the next however many weeks it is, they're going to continue to remain in that position. These people are going to have a lot to talk about once this trial is over, guys.
I mean, shoot, they took them a month to pick them. They went through 200 plus people to get to those 16. So that's 12 plus 4 alternates, 10 of them being men, 6 women, as I understand.
And one thing, let me give a shout out to both lawyers. The composition of this jury is truly a jury of this young man's peers. I'm old enough to remember the bad old days when we had all white juries in virtually every case. I mean, it was something that people don't like to talk about. And I am thrilled for the fact that win, lose, or draw, that at the end of the day, this young man will face justice by a jury that's composed of a cross-section of this great county.
Letitia thinks the jury stacked a little bit in the defense's favor because of the grandma factor.
And that's a great point, because let's just say that people whom I've spoken to in the prosecution team think that was one of their worst fears, the mama bear factor. And if there's a mama bear on this jury, then this could be a very difficult trip for John Jordan and Ryan Trask this third time around.
As a mama bear, there is a secret sorority with mama bears. And we love our children, and we love our children dearly. And before you get me to lock up someone else's grandbaby or child for the rest of their life, you better prove your case to me beyond a reasonable doubt. And I'm sure that that's what they were talking about when they said they were afraid of Mama Bear.
How do they get around that?
Look, remember, it's not jury selection. I think our viewers are smart enough to understand that. It's jury elimination. You take the people that keep you up at night and give you gray hair. And I don't think that there's any spoiler to the notion that Ryan Trask and John Jordan, more than almost anything else, fear to Mama Bear making their way on the jury.
As they should.
Okay. So my brain is kind of cooked at this point in the day. And you're giving me a wrap, so it's working out perfectly. I think we are going to wrap it up. But just before that, we got to just dot our I's and cross our T's real quickly to get it all nice and clean. So the next thing that's happening is on Monday. Is it bright and early?
Monday, 10:30 a.m. This is where it will hopefully get opening statements at this point. I'll make a quick note. I should have been more mindful. I didn't see any poster boards. That should have told me immediately that this wasn't starting today. So Monday, I'm going to keep an eye for poster boards and let everyone know if we believe it'll start at that time. Monday, 10:30 a.m.
And we're going to be benching it. The bench will be going full strength at that point. And you can see the other stuff we have available to you there. Interactive timeline of the case, detailed archives from the first trials. We really do have a whole bunch going online if you check. And I think it's /thebench on click2houston.com. That's all we've got for now. Are you good, Brian?
I'm great.
Everybody good?
Absolutely.
Okay, let's wrap it up for now. We'll see you again very soon.